Welcome back to Court TV Live. I'm Julie Grant. We've got the judge on the bench in the stranger home invasion murder case. And we're about to find out if the defendant, this guy here in the lime jumpsuit, is going to take the stand. Let's go in together. The judge is about to do what's called the colloquy, the question and answer session, where he advises him of his rights, make sure he understands he has the right to testify or not in his own defense. Here we go.
We are present here in the open courtroom. Present in the court, the clerk, the court reporter, Mr. Lanz, he's represented by Attorney Jimmy Berry, and the state is represented by Assistant Attorneys Green and Horowitz. Good morning, everyone. Good morning, Judge. Great. So, a couple of procedural matters I do have, which I'd like to give you all copies of the verdict form. So, Madam Clerk, if you could hand that to both the state and the defense so that they can review that for the court. Oh. I don't have a chance to review, but I just want to give you all a copy to review. You can keep that copy.
Okay, thank you, Judge.
All right. All right, and yesterday, before we adjourned for the day, the state did rest on their case, and so, Mr. Berry, I will allow the defense to proceed.
Thank you, Judge. I have spoken to Matthew about whether he would wish to testify. It's his wish to not testify. No court can ask him about that. At this point, he does not want to testify.
Okay, thank you, Mr. Berry. There are a few questions that I would like to ask Mr. Lanz to inquire about his decision on whether he wants to testify or not. And so, Mr. Lanz, if you raise your right hand for the court, please, sir. Do you swear and affirm that the testimony you will give to this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
No comment.
Okay, can you put your right hand down for me? Mr. Lanz, do you understand that you have the right to testify, and if you want to testify, that no one can prevent you from doing so?
No comment.
Do you understand that no one can make or compel you to testify? That is, do you understand that you have a right to not testify if you do not want to?
No comment.
Do you understand that you and not your lawyer must personally decide whether you will testify or not?
No comment.
Do you understand that if you do not testify, then upon your request, the court will not use your decision against you?
No comment.
Do you understand that if you choose to testify, you will be examined by your counsel and cross-examined by the assistant district attorney?
No comment.
Do you personally want to testify or not?
No comment.
Okay. Attorney Berry, do you stand in your place as an officer of this court, as well as Mr. Lanz's representative, that you have spoken to Mr. Lanz, that you have presented him with the option of whether or not he has the right, or he has the right to testify or not, and all of the issues or concerns with whether he does or does not testify, and also informed him that if he chooses to not testify, then the court will not hold that against him. But if he were to choose to testify, then he would be examined by you as well as the assistant district attorney. Have you spoken with Mr. Lanz and discussed all of this with him?
I have, Judge, and it's his wish not to testify today.
All right, thank you. Are there any witnesses that the defense wishes to call?
No.
Okay. All right. Can I have the attorney's approach?
Okay, we need to back the truck up here, because what I see as problematic for the record is that he didn't give a yes or no answer to those questions. You need a yes or no from a criminal defendant. No comment isn't an appropriate answer. If I were that judge, I would make him give a yes or no so that we know that he clearly understands. The last answer to whether he wants to testify or not, his answer was, quote, no, no comment. Okay, so we did get a no there, but everything that preceded that, that was all no comment. Let me bring in our legal analyst guest. I want to see what he says about this. John Day on the show. John, do you see this as possibly creating a problem and maybe an avenue for appeal for this defendant?
Yeah, possibly as problematic as you saw it, because the judge really needs to, and she can still do it, but she needs to go back and determine definitively what he is saying. No comment is a vague, non-responsive answer to very specific questions that the judge has to get an answer to. And this is really, really important. As you pointed out, this could be an appellate issue. And if she's thinking on her feet, she could go back. There's still plenty of time, obviously. Go back and say, look, I need to make sure you understand. I need to get your answer on the record. And no comment does not give me the information that I need. So, yes, it is problematic.
Yes, John, that's a great idea. Hopefully she's consulting with maybe her law clerk or someone in chambers and goes back out, because you're right, there's still time, the record's still open, and she can say, you know what, Mr. Lanz, I need further clarification from you. Let's do this again, and we have to be abundantly clear, because, John, you know this, and for everybody at home, this is a great teachable moment. We have to make sure, the court has a responsibility to make sure that his decision is knowing, intelligent, and voluntary in choosing to give up his right to testify in his own criminal case. And so if he doesn't fully understand that, you know, as you and I are noting here, John, for our courties who love digging into the law, later on, let's say he's going to be convicted, and he will be. He may try to have an appellate attorney say, well, you know what, let's look back at this record. Clearly, he wasn't answering yes or no, so clearly he didn't understand his right. He needs to be able to have that right exercised and understand his ability to do that. We got to go back and have a whole new trial. Nobody wants to see this case go back. John, tell me, are you surprised the prosecutor, you've been a prosecutor, are you surprised they're not standing up and saying, Judge, we got to clarify this?
Yeah, I was thinking that same thing as you were talking about it. I think the role of the prosecutor is to stand up and say, hey, can we approach, here's an issue for us. We need to make sure this gets on the record. And it is a little bit surprising that they didn't do that. It's certainly to a disadvantage to them if they have to, if the state has to deal with this on appeal. And it's a very simple fix. And again, it is surprising that the judge did not make a definitive determination with yes or no language. And she can go further. I mean, there's nothing that prevents her from delving into it deeper to make sure that he does understand. But leaving it at no comment, I think everybody is startled by that, because that's so vague and non-responsive and doesn't give us the information that the judge really needs to get.
Definitely, John. Well said. And you know this, different advocates in the courtroom are going to do different things. So his advocate right there, of course, he's not going to draw attention to that. His job is, potentially create an issue for his client, to get another bite at the apple. So he's not going to say it to the judge. But the prosecutors need to be on the ball here and make sure they flag it for the judge. They don't want this case coming back to their office. They've done a great job trying it. They're well on their way to a conviction. But if they got to do it again, oh my, that's just going to put the family through so much heartache.